Are we at number 9 or are we at number 10 yet? Now I gotta go back here. Oh, I can't go back. I'm recording, so I'll figure out the number. It's either 9 or 10. All right, let's see what else I wrote in here. Okay, after 1688, common law evolved as far as it could go, making equity the primary law of choice for courts and the people. At this time, AD 1688, through the Bill of Rights, the feudal land tenure system, and that before it was subject to a tyranny. Remember, everything is cheated back to the king. King was absolute ruler, namely one absolute ruler over land, moved into free and common socage. The monarchy was no longer assumed to be the common law owner of land, and that the people were serfs. Equity must follow the law inasmuch as it was bound to the common law trust, which noticed the right to split the legal title from the equitable and allow for them to be held in different legal persons. Under English law, subject to the primary split of legal and equitable law, are civil, admiralty, law, merchants, criminal, family, municipal, government, contract, and trust laws, just to name a few. All right, so let's just unpack that a little bit. The despotic monarchy ended in 1688. Okay, no longer, if you read that, if you read the very beginnings of the oh, gotta stop something. I gotta put a log on the fire. Hold it. I'm back. Okay. Yeah, I was gonna do an overview of what I was just talking about there. Okay, 1688. Read the Bill of Rights. 1687, 88. The James II abdicated the throne under pressure because he started to bring back some of the tyranny that was realized through the despotic monarchy. He started wanting to take control again. And prior to that, we had the Great Revolution. The Great Revolution, I believe it was, when there was a fight between the Parliament and the monarchy for control, whereby the Parliament, let's maybe get to that point, the Parliament could never, ever, ever, ever be greater than its creator. And that's a simple adage that we can implant in ourselves. You can never be greater than that which created you. So, as we talked at the very beginning, the Curie Regis was the father to the Parliament, to government, and it is the monarchy that created Parliament in the first place, to have certain interests, to hold certain rights over things. And Parliament, bottom line, is just the ones that are right to administrate under the trust. So they're just making, sort of just like the Lord Chancellor was, they each have divisional rights into controlling those interests in equity that are subject to a trust. Okay, that's what Parliament does. They have the use to land. They're held immediately to the common law in as much as they cannot overstep the common law foundation, because that's settled and was settled in 1688. They can only, though, administrate over the rights of the use to the land and make sure that those rights and those right rules and legislation for those rights as they develop, as people become more and more used to using that form of law than they do the common law or their dominion rights. Okay, and I know I digress, so I hope I can get right back to there. 1688, you were no longer subject. So James II, he was a Catholic, and as we know from King Henry the Eighth, we will get back to that character. King Henry the Eighth, who usurped all the land interests in the Catholic realm, were held by the Catholics, and gave it over and usurped it and took control of it to now arrive in the Protestant religion and then have the Church of England. So from that, everybody was now working within that dynamic, and we still had feudal and a lot of equity involving, where equity started overreaching a lot of the common law rights because they were more palatable and we couldn't destroy the trusts that evolved from it. So the James II started to throw his weight around it, for lack of a better word. And from the pressure after the Great Revolution, and he's received pressure from Parliament. Again, Parliament cannot overcome the monarchy. The monarchy is established because it holds the common law. It's not greater than the common law. It came from the common law. So he abdicated the throne, and they brought in William and Mary of Orange. And that instilled a constitutional monarchy. And the constitutional monarchy is now the equitable proponent, or the crown proponent of the monarchy, to which then deals with equity. Okay, that's an agreement between those parties. Now, if we, sorry, my mustache is tickling me. I must have something sticking there. Just like we spoke about, the barons have a succinct agreement with the monarchy, the lords having a succinct agreement with the barons creating the Magna Carta has a succinct agreement with the monarchy, had nothing to do with you. The church having a succinct agreement with the lords. See, everything is in agreements. Everything are segregated. Everything have different pieces or mechanisms driving them, and we commingle them often. And we're going to get to that, where that happens too often. And the Parliament could not then, once the king abdicated, of course they already had a preemptive idea of where they wanted to go to. They couldn't destroy the position of monarchy, who held the common law, because that's what gave them the power in the first place. That held the original tenure, or the original settlements of land, to which is still, to this day, is held in the monarchy. We never deal with that. You know why? Because we've given our rights to those possessions held in Parliament, and then we've purchased rights, those rights to use the lands, which are administrated under the government, to use the land as quasi-trustees. Okay, so that's what has happened. So 1688, you're no longer subject. It also give parliamentary privilege. The first time you hear the word parliamentary privilege to government. And what else it did? Oh, it removed the common law right of the monarchy to be the absolute ruler of over all land. Okay, it is held, and this is very important, and this is where we get to your power and your dominion. It recognized, since they recognized natural law, that, as we explored in Blackstone's at the very beginning, that we have to move the land back into the people in order for the law to be lawful, and them to control their own rights. So they understood the practice, or the explanation of dominion. So all land naturally moved into the people, and no longer was a despotic monarchy, and the Game of Thrones ended. And from that point on, we start moving into what's called free and common soccage. It's no longer based on the feudal land tenure system. We moved into, there was feudal, ancient, and modern, so now we're into ancient law. The ancient land tenure system, or ancient land holding system of law. And we're beginning there. It's a new settlement. See, everything's a settlement. 1086 was a settlement. The Theophments were settlements. Everything's a settlement. And they're derived or held together with some certain duties and powers that live as a fiction, because fictions are agreements. They don't exist in nature. They exist through the minds of men, which is the God of men, God of law. I digressed a little bit again. So 1688 was that point where they moved the rights of divine privilege. That's not the word I was looking for, but anyways, prerogative, to be the absolute holder of land, where land all is ceded back to the monarchy as common law holder. They are ceded now as an equitable right to the government, or what the society had agreed to. And that's the confusion. When you think you're part of society, you are people of society, but there's also the people or the individual within the class of people that has held dominion. And we'll hold off there because I see that we're running about 10 minutes, and we'll try to keep these short.